In this statement, I ask that you consider the proposition that state government monopolies of printing ballots violates the individual's First Amendment right by abridging the freedom of the press and the individual's right to vote, which is embedded in the 10th Amendment. By way of introduction, my name is D. Frank Robinson. I'm a co-founder of the Libertarian Party. Now, until the late 1800s, all ballots, that is, votes recorded on paper, in the United States were cast as write-in ballots. Voters prepared, that is, they published their own ballots or used pre-printed ballots published by political parties because there were no state-imposed restrictions on whose name could appear on the ballot. Individuals could always vote for the candidates of their choice on self-published ballots or by editing the ballots furnished to them by writing in the names of their preferred candidates. The system of a state monopoly of prepared ballots, known as the Australian ballot system, was introduced in the United States in 1888. The state monopoly ballots were considered a progressive reform to reduce fraudulent election practices. However, the new state monopoly ballot publishing system also operated to restrict the voter's choice of candidates. The effect of this progressive reform was to establish a state monopoly on the use of paper for the purpose of casting, that is, publishing, a citizen's vote. In response to this problem, several early state courts recognized the right to cast write-in votes. These early decisions emphasized the voter's choice as paramount to convenience asserted by monopoly administrators. In Santer v. Patent, Illinois, 1895, quote, "If write-in voting is prohibited, the voter is deprived of the right of exercising his own choice where this right is taken away. The boasted free ballot becomes a delusion." In another case, Patterson v. Hanley, this was California in 1902, quote, "It seems to be agreed that the voter must be allowed the privilege of casting his vote for any person for any office by writing his name in the proper place." In Autumn v. Black, Pennsylvania, 1905, quote, "Without a provision for the voter to make up an entire ticket of his own or her own choice, the election as to that voter will not be equal, for that voter is unable to express his or her own individual will in his or her own way." Clearly, the state ballot publishing monopoly means that not all voters can vote for the candidate of their choice without a self-publishing or write-in option. The effect of the publishing monopoly is to make some candidates privileged by the state ballot monopoly and marginalizes all other candidates who, in effect, lack a license from the monopoly to appear on the ballot. Ballots became a publication subject to editorial control by politically appointed administrators of those partisans who hold office at a particular time. This editorial control of the ballot enabled those political partisans to further entrench their control of all other state activities. By 1974, in the Supreme Court decision Lubin v. Panish, even the Supreme Court recognized that the operation of this state ballot publishing monopoly meant that not every voter could be assured, quote, "that the candidate of his or her liking will be on the ballot," unquote. Or, in the court's opinion, censorship was an exception to the vaunted rights proclaimed in the First Amendment. The present balloting system in the United States is now a censorship regime administered by two long self-entrenched cliques of partisans whom voters, candidates, judges, and political parties almost unanimously accept this censorship as constitutionally necessary, proper, and even indispensable. The ballot access disputes litigated and the reforms proposed now involve merely the administrative details of all the various 51 publishing units of what is one national ballot censorship cartel, such as which quotas apply under what circumstances, and yet still insulate the ballot censorship cartel from competition by the voters themselves. And of course, competition is always the bane of entrenched monopolists. I have concluded that Article 1, Section 4 and Article 1, Section 5 place the regulation of elections in the Congress, and states may only act as agents of Congress to hold elections. Therefore, state ballot access censorship is an usurpation of congressional power, and all state ballot access laws are unconstitutional, even if Congress has, and not even Congress, has the power to monopolize ballot publishing and ballot censorship. There are alternatives to the editorial censorship of the ballot, short of returning to a freelance, although constitutional, ballot publishing. The right to publish your own ballot is analogous to the right to manufacture your own firearm. Hopefully the former makes the latter less needed. I propose one possible alternative: domestic adoption of a uniform or universal write-in ballot, similar to the federal write-in absentee ballot now used by citizens residing outside the United States. This electoral system reform should not require a constitutional amendment, since the Constitution already provides that Congress may legislate the manner of state authorities conducting elections at any time for at least federal offices, if not all elections, as the Supreme Court has construed the 14th Amendment. With this ballot reform, Congress may allow the states to still publish content-neutral write-in ballots and offer them free of charge to the voters, but their monopoly powers of discrimination by censorship would end. I intend to deal with other predatory electoral practices by the Democratic and Republican partisans in the future. Now let me note that the opinions I have expressed here do not represent the official position of the Libertarian Party yet.